Next case on the docket is BOSQUE versus RIVERA. Okay, we'll have 20 minutes.
Good morning, Your Honors. May it please the Court. My name is Justin Presser. I'm with the Nation Law Firm here for the appellant, Joshua BOSQUE. If I could reserve 5 minutes for that. The two narrow legal issues before this Court are, did the appellee prove fraud on the Court by clear and convincing evidence in the trial court? And if so, was the ultimate sanction of dismissal warranted, and thus was BOSQUE actions so egregious warranting dismissal? Fraud on the Court has been defined by this Court as where it can be demonstrated clearly and convincingly that a party has sentiently sent in motion some unconscionable scheme calculated to interfere with the judicial system's ability to adjudicate a matter by improperly influencing a trier of fact or unfairly hampering the presentation of an opposing party's claim or defense. Further, the Florida Supreme Court has said that without intent, you cannot have fraud. In the instant case, it's not the appellant's burden to prove the absence of fraud, but rather the appellee's burden to prove the presence of fraud, and to do so by clear and convincing evidence. In the present case, there is absolutely no evidence to support the appellee's accusations that BOSQUE's omissions were intended to impair the trial court's impartiality or stymie the appellee's defense. There's no evidence that the omissions were anything other than innocent explanation, than as the result of innocent explanation such as forgetfulness or stress under a high-pressure situation, such as deposition.
How long had the prior accident occurred? What was the difference in the time span between the prior accident and this current accident?
The prior accident, Your Honor, occurred on, I believe, June 27th, 2006. Mr. BOSQUE was 16 years old at the time. At the time of his deposition, he was 21, and that occurred on September 19th, 2011.
So
over 5 years had passed.
Okay, about 5 years, and he couldn't remember you're saying he just couldn't remember the prior accident?
Your Honor, what I'm saying is we don't know why the conflicting answer was given.
He certainly didn't disclose it, did he?
Your Honor, he actually did disclose it, just not through interrogatories, not through his deposition.
I mean, when he was asked the question, had he been involved in any prior accidents, he said no.
He did say no, Your Honor.
He didn't disclose it.
Correct. He didn't. He omitted at that point, but he did submit a record.
But you're saying that he had disclosed it through other discovery?
Yes, Your Honor.
What, such as?
Specifically, on the day of the accident, he received treatment at Sunshine State Medical. He told his medical provider that he was previously involved in a prior accident. That's referred to in our brief as the Sunshine Note. That note was turned over to the appellee in the normal course of discovery without objection. So, at the time of Mr. BOSQUE's deposition,
If he remembered to turn that note over, how is it that he remembered the accident to begin with? I mean, he couldn't remember the accident to begin with. You're saying he couldn't remember, yet he turned this discovery over, saying that there was something in there that indicates that there was this prior accident.
Correct, Your Honor. And he may have forgotten for a number of reasons. It could have been the passage of time, it could have been the stress of the situation, but the fact that he had produced a note and the fact that he had told his medical provider that he had been in a prior accident and then turned that note voluntarily over to the defense would seem counterintuitive if you're trying to cover up a prior accident.
Just so I'm clear, his non-disclosure occurred in March of 2011 in his written interrogatories, and then 6 months or so later at his oral deposition. Is that correct?
Yes, Your Honor.
Doesn't that seem a little odd that, I mean, I don't know that answering interrogatory, I can understand that a deposition can be stressful. I'm not sure that answering interrogatories is all that stressful. You come into the office and sit down with the paralegal or the attorney and take them home and think about them. And
yes, Your Honor.
It doesn't really seem like it's all that stressful to me.
And it may not be to you and I, but as someone who doesn't do or isn't involved in the legal field, it may be a high-stress situation. But in any event, even the failure to disclose it in the interrogatory and his deposition, the note stating that he was in a prior accident was in the appellee's hands at the time of his deposition, and no follow-up was made.
Well, let me ask you, was his answer to the interrogatories inaccurate? I mean, wasn't the question, were you in an accident in which you received medical treatment?
Correct, Your Honor, and he did respond no to that. Now,
Was it your position he did not receive medical treatment?
he didn't receive any medical treatment related to his lower
is that
back. It
an
was a simple
accurate
cut on the arm.
So is that an accurate answer in the interrogatories?
We would argue that it is an accurate answer based on the way the interrogatory was written.
All right, so you have interrogatories with an accurate answer, you have a request to produce, where he produces this medical record, and you have a deposition with an inaccurate answer.
Correct, Your Honor.
Okay.
And at the time that he gave
Was
his
it in that order? Interrogatory, request to produce?
The interrogatories and request to produce were done at the same time. They were submitted at the same time to the defendant. And then once the appellee received an incorrect answer in the deposition, there was no follow-up. They didn't attempt to show him the sunshine note and refresh his recollection. There was no follow-ups in order to try to get him to either change his answer or try to direct him to acknowledge that he had been incorrect.
What was all of the references I saw to subpoenaing his records from Herzing University and Aloma Urgent Care, which led them back to this accident? Help me go through that.
So, Your Honor, during the course of his deposition, they asked him where he had sought an education at. He mentioned Herzing University. The appellee then subpoenaed the records from Herzing University, and inside of those records received as a student was a physical examination done for, I think it was a physical therapist class, and that was done at Aloma Care. Now, we don't know who the doctor was. It's unsigned, it's unverified, but within that note itself, which they received from the Herzing subpoena, it said that he had prior motor vehicle accident, which, again, was already disclosed in the Sunshine State medical record, and it also said that he had a prior low back pain, but no pain complaints on the date of the examination.
Do we know, is there anything in the record whether that note was accurate or inaccurate?
There's nothing in the record to support whether it's accurate or inaccurate. There was no testimony taken at the trial level for the hearing on the motion to dismiss. The hearing lasted a little under 30 minutes. No testimony was taken. No evidence was taken.
So we have a note with unsigned in university records, and that's all we have?
Correct, Your Honor. And again, we go back to the burden is proving, the court has set such a high standard for dismissing cases and giving the ultimate sanction of sounding the death knell in a case because of the constitutional protections to bring cases and have courts hear and redress injuries. That's why we have this clear and convincing standard. So,
Now the note said there's an accident 2 years before.
correct, Your Honor, and that was inaccurate.
And that was inaccurate.
It actually had occurred, I think, 3 years before.
Is his name on the note?
Give me 1 second, Your Honor.
And I know the note's in his records, but is his name on the note?
Your Honor, it is handwritten at the top of the note, but again, it's unsigned. We don't know who the physician was.
So it's handwritten, his name on top, one sentence note?
Correct, and it essentially says, patients here for a physical examination for a PTA course. History of Tourette syndrome, history of low back pain, motor vehicle accident, there's a SP, I don't know what that means. Motor vehicle accident 2 years ago, 0 pain day, and then it mentioned lower back pain under chiropractic evaluation. I think the appellees referred to it as chiropractic treatment, but there's nothing in the record to show that the evaluation was anything more than that, a single evaluation. We don't have multiple dates of treatment in the record, and we have no evidence of that.
Does it say he's approved to take the class?
Excuse me?
Does it say he's approved to take the class?
It actually does not say that, Your Honor.
Okay.
The court, if I understood your earlier answer, the court did not take any evidence from your client, is that correct?
Correct, Your Honor. Mr. Voss did not testify.
Did you have an opportunity to have him testify if you had wanted to have him testify?
It was not scheduled as an evidentiary hearing. It was...
You asked to offer his testimony, and the reason that I'm asking is it talks about, calculated to interfere, which seems to suggest an intent to interfere.
Correct.
So was your client given the opportunity to testify, or did the judge say, well, we're just going to take some argument?
And Your Honor, I don't know the details of how the hearing was set and the underlying. What I do know is that from the time that the defense, the appellees filed their motion to dismiss to the time they set their hearing, they never sent any interrogatories, they never asked for a second deposition of Mr. Bosque in order to try to get different answers, or in order to try to understand why there were these certain omissions. But as far as whether Mr. Bosque had the opportunity or not, I don't know. And again, the standard is, the burden is on the appellees to prove by clear and convincing evidence the presence of fraud. It's not on the appellant or the plaintiff.
The trial court apparently thought that was established. I mean, I find this case does rise to the level of egregious misconduct. It's clear and convincing, and it eviscerates the defense's ability to provide a defense, and does rise to a scheme to defraud. And so I understand the clear and convincing, but really the standard that we look at in determining what the trial court did was abuse of discretion, right?
It is an abuse of discretion, but it's also a narrowed abuse.
By the clear and convincing, I understand that, but the trial court apparently found that all that had been met.
Correct, and at this court, the abuse of discretion standard is not your general abuse of discretion standard, because you're looking at the ultimate dismissal of the
So your
ultimate
basic
sanction.
argument is there's not clear and convincing evidence that there was a scheme to defraud?
I'm sorry, Your Honor?
Is that basically what you're saying, is not clear and convincing evidence?
Your Honor, we're saying there's not clear and convincing evidence, and there was actually no evidence of any scheme or any intent to intentionally withhold these responses or withhold this information. Again, if you look at the facts of the case, the facts belie the argument that Mr. Bosque was intentionally trying to withhold this information by telling his medical provider and producing that note.
Is there any fact or scenario that the trial judge had a better vantage point than we do? I mean, we have the interrogatories, we have the deposition, we have the request to produce. There's no live testimony. Is there anything the trial judge had that we do not have?
No, Your Honor. You have the cold hard record right in front of you, and that's why the abuse of discretion is narrowed, because you have the same record the trial court had, and because we're dealing with the ultimate sanction of dismissal. And just so to be clear, even if there was clear and convincing evidence, that doesn't necessarily necessitate that the dismissal should stand, because that should only happen under the most egregious set of circumstances. There were other options available. If the trial court had felt that Mr. Bosque was untruthful or had intended to commit some sort of fraud, they could have done several things, including order a second deposition with Mr. Bosque, paying the penalty of hiring the court reporter, paying attorney's times. I mean, there were other sanctions available to the trial court if indeed they did find there was clear and convincing evidence. When you look at the cases that this court has dismissed for fraud, those are cases of clear fraud. If you look at the Brown case was a UM case. The plaintiff attempted to bring a lost wage claim. It was proven through employment records of the plaintiff that he was actually terminated from employment the day before the accident. And the wage loss claim made a huge portion of what his UM claim was, and this court dismissed that. If you look at the Sun case, that's an instance where not only the plaintiff, but the plaintiff's family admitted to lying over a 6-year period. So the egregiousness also comes in, but you also look at the clear and convincing evidence. So you look at Brown and you look at Sun, there you have instances of clear and convincing evidence. You have records in the file indicating fraud, and you also have, in the case of Sun, admissions of committing fraud on the court.
Okay.
And I'd like to reserve the rest of my time.
Okay.
Thank you, Your Honor.
morning, Your Honors. My name's Kansas Gooden. I'm here on behalf of Eric Rivera. May it please the court? This is not a case about a mere testimonial discrepancy, which the appellate would lead you to believe. There was much more than not disclosing this prior accident. He also did not disclose two medical providers, the Aloma Urgent Care or this chiropractor.
Well, let's talk about that. Is it a medical provider if you take a physical exam for a class?
I would argue that it is a medical provider. It is a doctor you go see. I would
They're not
constitute...
providing services. I mean, they're evaluating you for the benefit of the school, right?
But it is still providing a service and evaluating your
They're
health.
providing a service too.
Correct.
Okay.
Correct.
I mean, you'd agree it's ambiguous enough where that would not be a fraud? I mean, if you go in for physical and you don't list that as a doctor or provider?
I would concede that, Your Honor, but again, he didn't disclose the chiropractor then.
Let's do one at a time. So you'd agree that not listing who you may have seen at a school to take a physical for the benefit of the school would not be a fraudulent act?
Correct, Your Honor. We would concede that. That would not rise to the level of clear and convincing.
What if the note is incorrect? Where would the fraud be? Then all you'd have would be the statement on deposition. I mean, what if the trial judge dismissed this case, and we don't know if that note's accurate or not?
Well, what those notes came from were directly from Mr. BOSQUE. The doctor would not make that up.
We have a record, right, but you could have you ever received medical treatment and the patient mumbles, and the doctor puts yes or the doctor puts no? I mean, maybe it's accurate, maybe it's not. I mean, he didn't write that. No one's suggesting that those notes are from Mr. BOSQUE. I'm just asking you, what would be the result here? I mean, would the result be a fair result if he had never been a chiropractor, for instance, and the note was just wrong?
That, is outside the record, because there is no evidence that there is no chiropractor. There is no evidence of that.
There's no evidence that there is or isn't. All there is evidence is an unsigned note in a university student record says under chiropractic evaluation. We don't even know that's treatment either, but that's all we have.
Yes, and our argument stems on...
So shouldn't we at least find out if it is an accurate note or not?
I don't even think we have to go that far, Your Honor. There was a sufficient basis when you look at everything as a whole. The trial court had a reasonable basis to dismiss this for fraud.
Well, what else do we have? We have the medical provider, and we've talked about that, where it's a physical. We have the note. Now, would you agree his answer in the interrogatories was accurate? Because were you in any prior car accident in which you received medical treatment?
I do not agree with that, Your Honor. If you actually look at the EMS records from that accident, which was in the supplemental record the appellant filed, he did receive medical treatment. He had a laceration to his arm and was treated by the EMS. What he did, he refused transport to the ER, but he did receive medical treatment for that laceration.
Well, the specific question, though, list any accidents for which you have reported an injury. Not, so, I mean, I don't know what's in a 16-year-old boy's mind, but he may not view, what the medics put down as a laceration, he may have just viewed as, I got a scratch, and I don't view that as an injury. I mean, it seems somewhat vague. There are ways that you could read that would support your argument, but there are also ways, the EMS is going to put any kind of a scratch down as a laceration, and it could be this gaping wound, and it might be just a little thing that they stuck a Band-Aid on. We don't know how significant it is because there's no evidence.
Correct, Your Honor, but if you go to the deposition testimony, he was directly asked, have you ever been involved in a prior accident? No. Even as a passenger? Yes. So no prior accidents?
Right.
No, and that's unequivocal.
So that's what you have. You have an answer in a deposition which is inaccurate, and you have a note in university records that may or may not be accurate. Is there anything else? Because you have this medical provider versus someone given a physical, so that's kind of vague, and then you have the interrogatory, have you ever reported an injury, which his answer may well have been accurate, maybe, it's kind of vague there. So do you have anything besides those two things? You got the note in the records, and you have the answer to the in deposition about the car accident, or not having one? Anything
Yes.
else?
And going back to the chiropractic care, what Mr. Boss' actions did was to deprive Mr. Rivera of obtaining those chiropractor records in his
That
defense.
goes to my question, what if he had never been a chiropractor, or never had chiropractic treatment? We don't know that from the record.
But if he would have disclosed it or not disclosed it, I mean, there was nothing in the depo or the interrogatories to even would have led Mr. Rivera to subpoena. There was no identity of this guy.
What if he's never been to chiropractic, he's never had chiropractic evaluation? What if the note is inaccurate on that point?
But at that
Should we
point-
have, should he have an opportunity to, you know, should you have to prove he did get evaluation, or?
He had that opportunity. He could have requested an evidentiary hearing. He could have filed an affidavit saying, I never saw a chiropractor.
Who has the burden of proof?
It is the defense here that has the burden of proof, but however, I do want to point to the first DCA case, the Des Stefanano versus State Farm. In that case, the appellant claimed, I have a bad or forgetful memory, and the court said the appellant did not submit any evidence that she had any physical or mental problems, and the deposition showed she was capable of understanding questions and answering them fully, and that's what we have here. If you read through the deposition, it was very clear he was very capable of understanding questions. He remembered the accident and his medical treatment vividly, and when he was asked something that he didn't remember, he said, I don't remember, I don't recall. But he never, when he was asked about the prior accident, he never clarified those questions.
Let me ask you this. The note says chiropractic evaluation, right?
Correct.
Would you agree evaluation is different than treatment?
It could be, evaluation could be just mean an initial visit to the chiropractor where they have the x-rays and the chiropractor looks to see if anything's actually wrong, but it could mean treatment as well.
So we don't know.
No, we do not know. But again, we were never given the opportunity to know because Mr. Boss never provided any evidence on it.
You had the note before his deposition, right?
The Alona urgent care, we did not. We actually got that a month after his deposition. At the deposition, he said, I go to Herzing University. The defense attorney went back to his office, and first he did a request for production to Mr. Bosk, and he said, I don't have any records. He then subpoenaed the university directly. That's when we got this Aloma urgent care record saying prior automobile accident, chiropractic evaluation.
I mean, you could have done interrogatories or whatever. There's never a request after that to ask him, have you ever been a chiropractor?
No, there was not. And at that point, the defense attorney hired a private investigator, and the private investigator then uncovered this prior accident, which was a high-speed rollover accident over on the Greenway. I mean, it was a very major accident. The sheriff estimated about $10,000 in PD damage to the vehicle he was in. So, I mean, it was not like a minor fender bender in a parking lot by any means. This was a major accident.
Let me come back to the standard by which we're supposed to take a look at this. First, because the trial judge didn't take any evidence, are we required in any way to defer to his fact-finding, since his fact-finding is based upon the same records that we have in front of us?
It is an abuse of discretion standard. However, as with any standard of review, that standard takes into account what's going on in the trial court, and it has to take into account that clear and convincing evidence. But
this isn't a situation where he listened to a witness, he didn't listen to Mr. Bosk testify and say, I just don't believe you. When you said you forgot, I think you're a big liar. He didn't do that. He had in front of him what we have in front of him, and he drew the conclusion that this was a scheme to defraud the court.
correct.
My question is, are we required to defer in any way or give any deference to that finding, since we're in the same position that he is to look at these records?
Like I said, it's an abuse of discretion standard. However, there is a second DCA case, it's the Jacob case, that says your deference is narrowed somewhat because you are looking at a cold record. And we would concede that point. But just to clarify, are you asking whether an evidentiary hearing was absolutely required in this situation, or the trial court should have done an evidentiary hearing?
Well, let's talk about that a little bit. You know, we have said in various cases, and I don't think this is unique to our district, that this sanction is reserved for deliberate schemes to subvert the process, a deliberate scheme, which is another way of saying calculated to interfere with the process. To me, that suggests intent. And I realize that intent is very rarely, is there going to be some document that says, boy, do I intend to defraud the courts. It's going to be implied from surrounding facts.
Correct, Your Honor.
The only facts that we know for sure are what these records show. We don't know what Mr. Bosque's explanation is because there wasn't an evidentiary hearing. If the burden is on you, do you think there was a burden for you to give Mr. Bosque that opportunity and say, well, tell me why this happened, even if it's in a deposition or something?
Well, 2 points in regards to this. There's no, maybe an evidentiary hearing may be the best course. However, there's no rule, statute, or case absolutely requiring one. And there's a plethora of case law throughout the state of Florida that has affirmed cases where there was no evidentiary hearing. This court did it in Brown v. Allstate, which Your Honor Sawaya and Your Honor Orfinger were both on that panel. There's also the Destinano case, the Ramey case, Leo Golf Liquors, Long, Bass, McKnight, Savino, the list goes on. These are all examples where the court had a sufficient basis and there was no evidentiary hearing, and each of these affirmed. Now,
Let me ask you this. What if you did a supplemental interrogatory on the chiropractor, and the answer was, yes, I did have a chiropractic evaluation on such and such a date. You know, maybe I got one more treatment, maybe I didn't, or whatever. So you did a follow-up and they gave you an answer. Would you have a basis to dismiss for fraud on the grounds that the first answer had been incorrect, saying no medical provider?
absolutely not, Your Honor. At that point, it would not be fraud, because he corrected what he did.
Okay,
then.
we don't know if you'd done interrogatories whether it would have been corrected or not, right?
We do not know. But my last point on the evidentiary hearing, this Fort DC case, Savino, Mr. Boss never asked for an evidentiary hearing below and never objected to the hearing, never made that argument, and he didn't make that argument in his brief, and it's our position that it's not preserved for appeal. And so, again, I just point to the Savino case with the 4th DCA because they similarly found that situation.
A little while ago, you described this prior accident as being a rather serious accident. It was a rollover accident. Is that evidence contained in the record?
Absolutely, Your Honor.
Where is that in the record?
It should be in the supplemental record submitted by the appellant. It had the police report along with the EMS record on that.
To establish fraud, I mean, for you to prevail in this case, would there have to have been chiropractic treatment that was not disclosed?
In the long run, I think it's irrelevant or not. We have this record stating there's chiropractic care, and that was never disclosed. And I think in the long run, that's what it's going to boil down to.
A question, if there had not been chiropractic treatment, should the trial judge have dismissed the case?
In that situation, no, but I think the appellant needed to come forward with an affidavit or something that said, I never had chiropractic treatment, it just never happened, and he didn't do that. He didn't come forward with any evidence as to, oh, I forgot the accident, or I didn't have chiropractic.
This actually said chiropractic evaluation, so if in fact he had one evaluation, would that be a basis to dismiss?
If he did in fact have it, absolutely. Because what happens at that evaluation is x-rays are taken. Our CME could have looked at those x-rays. In the McKnight case, the court said keeping evidence of prior medical history from the jury would be interfering with the jury's ability to adjudicate the facts. and that's what our position is that happened here. I would like to make 4 points on the Sunshine State record that the appellant mentioned that said prior accident. First, this court wrote in Cox that a system that depends on an adversary's ability to uncover falsehoods is doomed for failure. And that's exactly where the appellant's argument lies in this case. Number 2, the record said prior accident. It did not specify prior motor vehicle accident like it referred to the subject one throughout the record. It could have been a slip and fall, a work comp injury. It could have been any other kind of accident. And on the very day that record was disclosed to the defense, he answered those interrogatories stating there were no prior accidents.
Well, that's not what he said.
He said none.
No, he said there are no prior accidents in which he reported an injury.
Correct. And that is the standard Florida Supreme Court interrogatory.
That's probably inaccurate.
Again, we do not believe that's accurate just because of the EMS record.
But the EMS doesn't say he reported an injury.
It says that he did receive medical treatment and was injured. It lists in the injury section a laceration to his arm.
Injury. If someone shows up and looks at your arm, says you got a cut, puts a Band-Aid on it, that doesn't mean you reported an injury.
Well, it's still medical care, and I would argue that it is reporting an injury to the EMS if they are rendering some type of care to you.
What would be the incentive of the plaintiff wanting to hide a prior accident in which all we know there was just a laceration and really nothing in the way of treatment? If the standard is fraud, and you have to establish that by clear and convincing evidence, how would that be? Why would anybody want to engage in a scheme to defraud if there was just to hide a prior accident?
Several reasons. If you look at everything together, the prior accident and that chiro evaluation or treatment, whatever it is, that shows a prior pre-existing injury that would have been...
What injury are you talking? You said there was a laceration. I don't think there's anything in the record that says that he had a pre-existing injury other than he may have been lacerated by this prior accident. That's not disguising a prior injury.
If you go to the Aloma Urgent Care record, it says lower back injury or lower back pain.
Time frame between that record and the 2006 accident?
The prior accident happened on July 26, 2006. The Aloma Urgent Care record was on June 26, 2009. It was 3 years.
So we have no idea whether, if there was lower back pain, assuming there was, that it was related in any way to the accident.
But again, the defense was denied that opportunity to even get there and find that out. He did not list this chiropractor. There was no means to ever subpoena the records to even obtain that information. And going back to the Sunshine State record quickly, because I know my time's running out, if this record constitutes some type of actual knowledge of the accident on the behalf of the defense attorney, it also would constitute actual knowledge on behalf of the plaintiff's attorney, which would trigger his duties under the rules regulating the Florida bar under Rule 4-3.3, which basically says that you are not allowed as an attorney to set forth false testimony. If he knew there was a prior accident, he should have taken remedial means to correct that false testimony. The first DCA in Baker versus Myers Tractor set forth in footnote 1 exactly what that entails. It means contacting defense attorney and saying, hey, my client lied under oath, contacting the court and taking remedial steps to correct that false testimony. Mr. Boss never took, his attorney never took any steps to rectify this. And Mr. Boss actually never took any steps to rectify his false testimony. He never supplemented his answers in discovery, and he never submitted an errata sheet on his depo saying, I made a mistake, this is what it should have been. There was none of that. Instead, he relied on that testimony throughout this whole thing. He submitted no evidence as to...
What injuries are he In this particular in the current lawsuit, what injuries is he claiming?
Low back herniation that required a spinal surgery. And so causation was the most important issue in this case. And with causation, a defense attorney is trying to, show that it's not related to the current accident. And one way to do that is showing a prior pre-existing injury. And it's our position that chiropractic care, we were denied the right to even prove our case because of that.
You can still find out what, if any injuries he may have sustained in the prior accident. You're not prohibited from doing that, are you?
No, you're not, Your Honor.
Because you're saying that, I think you're implying there may be some correlation between the fact that prior accident he may have suffered some back pain and now he's claiming a back injury in this case. And there's nothing to prevent you in the event that you discover that, that he actually did receive treatment from the prior injury and did actually receive a back injury from the prior injury, and coming back to the court and saying, now we've got this new evidence, Judge, and here's what he was trying to hide. Would there be anything to prevent you from requesting a second hearing in the event that in this particular appeal that we found that there wasn't a scheme to defraud? The
only thing that would prevent us is Mr. Boss continuing to lie to the defense and lie to his own treating providers about what his prior treatment and his prior accident.
But you could find that out through depositions and discovery, right?
We could, Your Honor, yes.
Let me ask you this. If he was to say, I've never been a chiropractor, and you have an unsigned note somewhere, is that sufficient to overcome that and establish that he, quote, lied? I mean, you just said he lied. He's going to continue to lie. I mean...
But again, there was no means to obtain the chiropractic records in defense of the case, and it would unfairly hamper the presentation of the defense and unfairly...
You just said he lied about the chiropractor.
Correct.
Now, if he went to chiropractor and he intentionally said he hadn't, that would be a lie. If he hadn't been a chiropractor, then it wouldn't be a lie.
Correct.
So, to prove a lie, you'd have to prove two things. One, he said he had never been there, and two, he had.
Correct. It would not be a lie if there was no chiropractic treatment there, but it would still be a lie in regards to the prior accident.
And if you got an evaluation, not treatment, would that be a lie?
I would argue that would be, because it's still not it's not truthful disclosure under the Cox case, and in Morgan v. Campbell, the second DCA said revealing only some of the facts is not truthful disclosure.
Now, our court has said that a lie by itself is not sufficient to establish a fraud. There has to be an intent to, an overall scheme to prevent a fair resolution of the case, and that a lie can be resolved through cross-examination and impeachment.
Correct, but those cases, Your Honor, in almost all of them that you go through, the Bologna case, the Gautreaux case, the Granados, all of them, the plaintiff actually disclosed in its sworn answer to interrogatories the doctor, and the defense was able to subpoena the records and obtain those records in cross-examination. We were denied that opportunity to do that here. And for those...
Wrap it up, because you're 3 minutes over your time.
Yes, Your Honor. And for those reasons, it is our position the trial court acted reasonably within its discretion and has a sufficient evidentiary basis to reverse this, and we ask this court to affirm.
If you want, I'll give you a couple extra minutes, because she did go over a little bit.
Oh, thank you, Your Honor. I don't think I'll need.
Let me ask you this. It seems to me that if there was this prior accident and he did suffer injury in that prior accident and tried to hide it by not disclosing it, that's pretty serious. And I would be able to understand at that point why the trial court did what it did, but we don't have a lot of evidence in this record. Would you agree that in the event that they were to go back and through discovery determine that he was hiding a prior existing injury to his back, that they would be able to revisit this with the trial court and ask for the same sanction again?
Absolutely. I think they could refile their motion to dismiss for fraud, again, have a second hearing, beef up their motion, include whatever they needed to show the intent, and certainly those records would help. But I don't think, as it stands now, they have shown they have met their burden of proving intent. If I can just hit a couple points, we've talked a lot about the chiropractor and the failure to disclose. Now it's hurt their side from getting medical records. It presumes one thing. It presumes that Mr. Bosque remembers who his chiropractor is. So even if they depose him, he may very well say, I don't know who it is. I had a chiropractic evaluation, and I don't know who it is. They also presume that if he went to the chiropractor, that there's x-rays and, sorry, Your Honors, that there's x-rays or other films. Again, that's just an assumption. We don't know from the record whether or not there's in fact chiropractic treatment.
Of course, their concern is because your client has a vague memory on certain instances that they will never be able to discover exactly what happened because they're concerned that they'll never be able to get the pertinent information from him.
Correct, Your Honor.
And
But
he'll
if this court,
continue to fail to remember.
correct, Your Honor, but if this court affirms that kind of a standard, that kind of an argument, and endorses that, you're essentially taking it from a clear and convincing standard to one of forgetfulness. And this court has said, and this is Judge Griffin in the Bologna case, we all know that the capacity to remember and the categories of what we remember varies widely amongst individuals and depends on a number of common factors such as age, stress, fatigue, and emotion. So we know, regardless of, I think it was the first DCA case, DeSimone, saying that the plaintiff didn't present any evidence of mental incapacity, we know that at least this court has said, or Judge Griffin has said, without neurological deficits, you can still have widely varying abilities to remember. Yeah, and again, just one last thing, Your Honor, and I'll wrap it up unless there's any further questions. When you look at the Morgan case, which basically dealt with the failure to include some prior chiropractic or some prior medical pain and prior injuries, in the Fifth, we have our own set of cases that have fielded that law. You look at the Go-True case, the Bologna case, and I think the Ruiz case, which all dealt with the failure to identify all prior care and all prior injuries, and this court has held it's not sufficient, it's not enough. Inconsistencies, testimonial inconsistencies are simply not enough when you're going to sound the death knell into a plaintiff's case and give them the ultimate sanction. You need to prove by clear and convincing evidence that there's an intent to defraud, and they just never did that in this case.
Okay,
Thank you, Your Honor.
Okay, at this time, we'll take a 15-minute break. The lawyers are invited back to the lawyer lounge for coffee. I hope we have coffee back there anyway, and we'll start back in about 15 minutes.